Hi. Thank you for getting up early, because I don't know about you, but this is early in hacker time. So today I'm going to talk about kind of the unique situation that's going on right now between the police, the user, and encryption. So a little bit about me. I'm a lawyer, also a master's computer science student, specifically with a focus on information security. I'd like to be the go-between between the lawyers and the technologists, and hopefully help communicate the technology to the lawyers and the legal speak to the technologists. A lot of my research is in privacy, usability of encryption, etc. Previously, I interned at the EFF, which kind of really got me into this stuff, and I sometimes do criminal defense cases. So, little quick obligatory disclaimer, I am a lawyer, I'm not your lawyer, and this presentation is not legal advice. With that being said, here's a little breakdown of what I plan to cover today. There's a lot. So I'm going to do a brief overview of a lot of topics that touch encryption. There are a lot of talks on the Fifth Amendment and encryption and your right to not incriminate yourself, and I'll touch upon those issues. I'm not going to go into specific legal cases for the most part, but what I want you to do is walk away with a kind of more meaningful understanding of what it means to use encryption in the United States and kind of the issues that are being presented, so that when you see a news article, you're like, okay, I see where the issues are coming from. So the theme is basically why encryption is an altogether different beast. That's a quote from a judge, and I think this judge really got that it's different. And the usability of encryption right now is really reinvigorating the debate from the 1990s about encryption of data without technological or legal means to decrypt, and what are the proper legal measures that when you have legal access to a computer or to files, but don't have technological access. So knowing this, how should the user, the law, and encryption function? Should there be a means that if the law says you have the rights, the police have the rights to this information, and you can't technologically decrypt without getting a password, should that still function that way? So this is a quote from 1997, just right around the time of the crypto wars. Some of you were around for that. I was very young, but still around. And here's a quote from October 2014. And so people are really scared. This is Kami, who's the director of the Federal Bureau of Investigation. I'm sure many of you saw the articles that were coming out about the FBI really scared about encryption. So these government agencies are frightened by the moves of companies to enable encryption by default. And so this has reinvigorated this debate. So I just really like the four horsemen of the infocalypse. It's a term coined by Cory Doctorow, but usually the government uses software pirates, organized crime, and many of you have seen that Obama proposed making hacking a RICO offense. So organized crime, child pornographer, and terrorists. So it's no surprise that that discussion is coming up again. So something to think about. This is the bring it on track, and you're supposed to walk away with, thinking deeper about the issues. As it becomes more user-friendly, more widely implemented, how will the government seek to weaken it? You've heard golden keys, back doors that are front doors, etc. But under the law, should they and could they be successful in doing that? And I'll bring up some things that I think I'm going to talk on both sides of the issue. Here's where technologically, privacy, why encryption should be great, but also here's why the police are freaking out, and this is kind of why it's different in any other technological issue that they've encountered. So here's the quote where encryption is altogether a different beast. I felt like I should give the entire thing so that you can see it in its context. Specifically, my slides, despite being mostly legal focused, will not be gigantic blocks of text. But this is from a judge, actually, in a case citing another judge. So it's two judges we got out there that understand that this issue is complicated. But I've highlighted some interesting passages. For example, forcing an arrestee to reveal an encryption key may impinge on a defendant's right to self-incrimination. I'm going to talk about that. Specifically, that the Fifth Amendment has no warrant exception. I'm going to talk about that and why that's powerful. And then here's the next part of the quote from this case. The only solution may be to gain the encryption key from the arrestee. So specifically through immunity, and I'll talk about that as well. But these are some legal issues that are surrounding encryption. So I'm going to first start with usability, right? That's like where I think this all comes down to. The debates keep being reinvigorated when users are able to encrypt. Historically, many of you know, encryption used by few, the tools were not built in, they aren't available on all devices, they were flawed. PGP is a nightmare to use, as many of you know. But here is a little clip from some of the new documents that came out from Snowden in December. Specifically, they're talking about how encryption was used by foreign governments. It was most likely, if you encountered something that was encrypted, it was usually foreign intelligence because only those individuals had that power. So what does that mean when the government assumes a technology is only used by a certain group? So what has been happening? Well, iOS is encrypted by default. Android was like, great, we're going to do the same thing. And now the new Apple operating system is you have to uncheck a box to not encrypt your computer. And that's really big for the user, right? Like, they want to do as little work as possible. Even just checking an extra box from the basic user is not going to get them to encrypt. It's really difficult to make them take an extra step. So by doing it and enabling it by default, we're giving users encryption in a way that hasn't been before. So some of what I do in my graduate research is I took a survey, and thank you if any of you in the room took it. How are users using encryption? And so I did a little piloted study, and how many people password protect their phone, how many use disk encryption on their computer. There are about 477 users polled, and I'll go into this data a little bit more and kind of what it means. But what I really think is interesting, and I should, side note about this data, is I think most of the people that responded to this were from the InfoSec community. Thank you to InfoSec Taylor Swift, who retweeted my survey, and then 500 InfoSec people basically responded. But just keep that in mind, that that's where my data is coming from. So, 21% of the people probably don't password protect their phone. 213 people, probably out of 400, so that's almost 50%, don't encrypt their computer. And so it's, one of my other questions was, if it were easy to use and implement, would they use it? Only 10 people said, no, I will not encrypt or use encryption if it were easy to use. So I think people want it, so we have to kind of do it for them. And that's where we have that responsibility. So encryption by default, I talked about this a little bit. These are some of the operating systems in the past few months that have said, yes, I'm going to encrypt by default. Now, how did they respond? Well, the feds are not happy. The government's not happy. It's going to make things a lot more difficult. And now let's go back to 1998, where there was the war again. And so this is kind of, a reinvigoration of the crypto wars. So a lot of stuff has been happening. And even in Mitnick's case, people were saying, encryption, what's going on here and what does it mean? So let's talk about encryption in the First Amendment context. So briefly, this is what the First Amendment says. You can make no law abridging freedom of speech. So what does this have to do with encryption? Well, the crypto wars, U.S. regulations basically prevented the export of crypto. And anything longer than 50 bits or larger, 56 bits or larger, you could not send that or transport technologies with that. So that was in September 1998, and until 1992, or it was gradually eased up until 2000. There were exceptions made for certain industries, including insurance companies, medical health organizations, et cetera, but there was nothing for the regular user. and it was a pain in the butt. So crypto in 1999, basically they said it's protected by the First Amendment. Now there was no Supreme Court case coming out and saying this, but it's pretty understood that yes, this is something that's protected by the First Amendment. The source code is protected. So that means they can't outlaw it like they can other technologies or other goods. And so it has this great, strong First Amendment protection, and I think that's worth remembering, that they can't take that away. And so basically they said the functional characteristics of source code like overshadow its simultaneously expressive nature. So now let's shift to the next amendment, the Fourth Amendment. Here's the Fourth Amendment. Many of you, search and seizures, you need probable cause, a warrant to search. There are all sorts of exceptions to the Fourth Amendment. If you follow anything going on in the Supreme Court, like in the past year, the Supreme Court recently came out and said, no, they can't search your cell phone without a warrant when they arrest you, which was really, really big for privacy, because the court realized the importance of a phone and how it was a portal to other information. So the Fourth Amendment in this context is about lawful access to something. Traditionally, it was a means by the government to gain lawful access to something, including an electronic device. But what if the police have lawful access to a device under the Fourth Amendment, but it's encrypted? So the court has said, you have the right to search this. The police now have lawful access, but no technological access. And should technological access barriers defeat legal access barriers? The Fourth Amendment is very much about a balance between the government and people to be secure from them and the government's ability to hold people accountable for their crimes and to investigate them. So here are some places where I mentioned before, no warrants needed. So if you talk to your friend and your friend tells the police, that's, you're kind of on your own. A phone company, internet, other company. Another reason why encryption, I think, is more and more powerful and more used is that if there's no search warrant needed for your email because Google, it's traveled through Google unencrypted, that's traditionally not how it's worked under the law. You needed a warrant to check mail, to search mail. And so there's a problem here, and I think encryption is saying, wait, the third-party doctrine doesn't work, so let's implement it. Plain view, if they see it, you can't ask a police officer to ignore something they've seen, and a border search. If any of you are familiar with traveling on the border, you basically have very few rights as far as search and seizure. They do not need probable cause to search your devices, your computers, your persons when you are crossing the US border. And that's either out or in, but usually it's when you're coming back in. So what's probable cause? It's probable cause to believe that a crime has been or is being committed and that the items are subject to seizure by virtue of their connection to the crime. Well, connect to the crime, but so what does that mean in the use of encryption? Can encryption play a part in this probable cause analysis? If you're out there walking around and they see that that let's say you're crossing the border, where you don't need probable cause, but what is encryption? Does that say, hey, I'm a criminal? So in Spain, they arrested someone primarily for using RiseUp and using encrypted email. And I think that's really, really dangerous and very scary. But it does exist in some countries. In the UK, encryption is not liked whatsoever, and recently they've come out and said they wanted to ban encryption. But in the US, there's not really any case law around this. Can the fact that you have encryption on your computer play a role? Probably, in the sense that an informant can come in and say, hey, there's this guy, Bob, he's got brown hair and is 5'5" and red shirt and his computer's encrypted, you'll know he's the criminal. And so that, in that sense, it's not the fact that encryption is the thing that they're saying is a crime necessarily, but it's part of this totality of circumstances. And so anyways, the whole thing is yes, it could be a part of that cause, but how much should it? Probable cause, they kind of estimate, courts have never come out and said, it's about 45% sure. Like, you don't even have to be 50%, so it's not very much. But one of the things I'm doing research in is, what do people use encryption for? Believe it or not, there's not many studies out there that say users, use encryption for legitimate purposes. But I hope that it will create some space so that if a court does come across this, they're not going to say, well, encryption is not something that we're going to say, oh, well, you're a criminal, or because you have encryption on your computer, now we can arrest you. So one of the polls I did was, encryption is only for those who have something to hide. Most strongly disagree. And I think that's great that people are realizing that. So it's not necessarily that the people believe a crime is being committed. There are lots of legitimate uses for encryption, but you guys all know that. So one of my favorite XKCD strips, this wouldn't exactly happen, but because you can't have an involuntary confession, it won't be admitted into court. But this is kind of where the police are stuck, right? They can't get the key, or they can't decrypt without a password. So, Fifth Amendment context. This is probably the more interesting part of this. No person shall be compelled in any criminal case to be a witness against himself. And this part is going to be less of an overview and a little bit more in depth, because this is where the issues are really happening, and how you implement accessibility and usability of encryption is going to matter in this debate, because Touch ID is different than a password. And there are a lot of long case law about why that is, and I'll kind of touch upon that. Fifth Amendment privilege against self-incrimination, it's basically I plead the fifth. My counsel has said, I shouldn't speak, etc. It's slightly different than your Miranda rights. It's rooted in the Fifth Amendment when, they arrest you and they say, you have the right to remain silent, etc., etc. But it really only applies when you're in custody, your Miranda rights. The cool thing about the Fifth Amendment self-incrimination is you do not have to be a suspect to invoke it. These phrases are not magic, but and they don't mean absolute protection, but it protects the individual, so not a corporation, and you can invoke it at any time. And so a lot of people think, well, I can only invoke my Fifth Amendment right if I'm thought that I am a suspect or the police are questioning me. But in any encounter you have, whether it be a congressional hearing, just randomly chatting with a police officer, etc., you can invoke this privilege. And it's also important, really quickly, you can invoke it for a friend. So that means, imagine in the password context, you've told your friend your password, and the police are like, give us your password, but they also know they gave it to your friend. Your friend can't say, no, I invoke my Fifth Amendment right if it's your computer, unless there might be something that would incriminate him. And you could make that argument. It's very fact-based, but keep that in mind when you share passwords. So for the privilege, there must be compulsion, self-incrimination, testimonial communication or act. And how do we get to the point where the Fifth Amendment is triggered? So a laptop belongs to John Doe. He refuses to provide the encryption key when a customs officer asks and starts to walk away. They tell him he can go, but they're keeping his laptop because they have probable cause to believe that there's child porn on his computer. And they said they've been tipped off by an informant. And they want to hold it under Fourth Amendment. So they have this Fourth Amendment legal right to the computer. They have probable cause. We're assuming that this is the point where they say, okay, now give us your password. And he's like, I want to invoke my Fifth Amendment right. So compulsion is by a court order or by a grand jury. The police are not the ones who can compel you. A court or a grand jury are the only people in the government that can compel you. And so what the police have to do if they would like to compel you under the Fifth Amendment is get a court order or a grand jury subpoena to do so. And so self-incriminating, really quickly, supports a conviction, might lead to incriminating evidence. And this goes again to, you can invoke at any time. Absolutely, it doesn't have to mean you are guilty or that you committed any crime or that you have anything to hide. It could just be something that you do not want to say anything because you don't want to become a suspect. And here's some quotes from a court case. There's too many of those who should have been better advised views this privilege as a shelter for wrongdoers. They too readily assume that those who invoke it are either guilty of a crime or commit perjury in claiming the privilege. So in claiming the privilege too, the government can't say, well, now he's definitely guilty or she's definitely guilty. You just can't do that. Self-incriminating statement can be a statement that tends to increase the danger that you'll be a suspect, accused, prosecuted, etc., that they'll bug you about what you're doing in any kind of way. So testimonial, it reveals the contents of your mind. They're oral statements. That's pretty easy. Like if you're thinking about it and it's only in your head, obviously that's coming from your mind. Actions in that sense are a little bit more difficult, and I'll touch upon why that is. So courts have said, giving up a password is in fact testimonial, which seems really obvious, but it's great that courts recognize this. But what's a testimonial act? So providing blood samples, fingerprints, voice samples, and writing samples are non-testimonial and thus not protected. So fingerprints, notice that? That means Touch ID. They can take your finger and put it on the device and decrypt it. And you don't have a privilege to invoke. So keep that in mind when you're using biometric encryption or if you're trying to encrypt devices you're developing. The protections are less, and that's pretty rooted. And there was a court case in Florida, I believe, relatively recently that said that, and people were kind of like, oh my goodness, and it was like, all the lawyers were like, yeah, we know. How does this how does this interact with producing documents? And so this is where it's a trickier situation. The government can compel you if it's merely a physical act. It's just you have to do something physical, then it's not a problem. But when the physical act is somehow tied to the contents of your mind, how should they act and how can they compel you? So what does turning over documents reveal? And so where your right against self-incrimination really holds tight is this document, active production of documents. So it used to be physical documents, now we're thinking documents on a computer. So they have communicative aspects, and they have to implicitly communicate some sort of statement of fact. And usually the big ones are the documents exist, they're authentic, and they're in your possession. Now the problem here is that this is extremely fact specific. I wish I could say here's a really easy rule, you can all live by it and go on your merry way, but it's just case by case. So that's why it's not really worth talking about the 15 or so cases, because it just depends on the fact in the specific situation. But if the government can show with reasonable particularity, that's kind of I don't think they know what that means. Most people don't know what that means. It's legalese, but if they can show that when sought to predict that they already knew about it, it's called the foregone conclusion, then the act of producing it, the act of decrypting, for example, is not testimonial and it's not revealing the contents. So they can gather information another way, or they can grant you immunity. They can say, we are not going to use this evidence against you, or we're not going to charge you with a crime, so give us your password. You have to give them your password. That Fifth Amendment right, once they give you immunity for that information, you're pretty much, they're in the clear. So.
That's just immunity for that specific evidence, right?
Right.
Alien.
Right, yeah. So that's just for that particular evidence, and it's not in a broader, we're not going to charge you with any crime ever. So you have to be kind of careful there, but if they find something or they find it in a different way, they could use it. So how could they obtain information another way? Well, other evidence, they could bypass security, they could use a backdoor, brute force, etc. Now, there we go. If they can get this information without having to ask you for the password, that makes their lives a lot easier, and it solves a lot of their problems. So again, reasonable or foregone conclusion, if a third party has said that you possess the documents, then they have other information. If you acknowledge the documents existed on your computer, there's one of the cases specifically, the guy was crossing the border. He did not have his computer password protected, like regularly when it was sleeping, and they opened up his computer and they saw child pornography, and they were like, oh, we're going to confiscate this. And so they shut down the computer and go to restart it up, and they don't have the password, and they're like, give us the password. And he's like, no, Fifth Amendment privilege. And the court was like, nah, they saw it, it's there. Him giving up the password does not mean give up any information. There's no testimonial act here because we know it's already there. And so that's kind of a situation where the Fifth Amendment isn't going to protect you. So again, remember, like, the whole thing about encrypted data is that it has to be about the documents existing, that they're authentic, and that they're in the possession or control. So, like, I'm sure you're all going, please, like, tell me this isn't, like, always a foregone conclusion. And so only a few courts have touched upon this issue, but the courts kind of differ with regards to foregone conclusion. They don't agree on how to apply it or what fact scenarios will trigger a foregone conclusion. Some courts, for example, don't understand that empty computer encrypted is the same as a computer full of information encrypted. And so that's just like a little technological piece that they're thinking, well, the data's there, we know it's there because it's encrypted. And, other courts have said, well, empty space, like, could be encrypted. So just having possession of the computer that's encrypted doesn't necessarily say it's a foregone conclusion that documents are there and that they exist. And so that's really important. So again, this is extremely fact specific. So any self-incriminating testimony that he may have had by revealing the password was a foregone conclusion, and they were able to prove that he was the sole user and possessor of the computer. So simply by knowing that it was his computer, they said it was a foregone conclusion. And this is a little problematic, at least because there could be multiple users. Just because you have it in your possession, that's difficult. And it's a little broader than the foregone conclusion as it was applied to documents. So here, just quickly, in case you're interested, here's a list of the cases. In various courts, there haven't been any really recent ones. There was one in middle of 2014, and I think that's the most, but it was a state court. And so I circled kind of where these cases cover. So anywhere there's not a red circle, the courts have not talked about this issue, just not decided. And so it seems, like pretty new to the courts, and it's either going to expand, but the Supreme Court hasn't talked about it, so there's no rule of law in the United States as this applies. So you may have seen in the news something called the All Writs Act. Gizmodo said it was this 18th century law to unlock encrypted phones. Well, no. All of the laws are like 18th century. A lot of them are. The Constitution is old, and we still use those laws regularly, so the fact that it's an old law does not make it troubling. So it's nothing new. It is used by the federal courts to issue writs, court orders, to help aid the execution of a warrant. And so this is like often they'll use an All Writs Act to say to a company, please, help gather the documents that we need, or if possible, could you help us, if they had a backdoor, decrypt the phone, because it's easy. So it requires third parties just to assist. It's been used for a long time. It was enacted in 1789. The current version is from 1911. It's been amended several times since then. It's a regular tool used by the courts. And invoking the All Writs Act in these cases is to effectuate the warrants. They then themselves, these writs, don't command the companies to do anything. The act is a mechanism to getting the company's assistance where they already have legal access. So you can't use All Writs Act to bypass constitutional rights, and they can't use it if it's unreasonably burdensome. So there was a lot of chatter of, oh, the All Writs Act, they're going to use that to put back doors, like we're all doomed. And no, it can't be used that. If you are asking a company to implement a new procedure, put in a backdoor into their encryption or into their devices, that's unreasonably burdensome. They're going to have to spend a lot of time and resources to do that. However, if the backdoor already exists, so that may be why the government would like companies to put in a golden key, a backdoor, front door that is a backdoor. Then the All Writs Act would have that power to say, okay, use it so that we can get access to this information. So quick conversation about backdoors or the golden key. So Comey seems to think, the director of the FBI, that it's simply a matter of wording. And he's done everything he can to portray the encrypted future as a nightmarish world where child abusers, drug dealers, and terrorists, the four horsemen of the infopocalypse, run amok while law enforcement is fumbling around in the dark and they can't get access to anything. And he's shifting gears. He's saying, well, it's not a back door he's seeking. One news article called it a magical doggy door. Which I thought was funny. And they want to use this kind of front door, another term, with clarity and transparency. What does that mean? Well, that basically they want to weaken encryption so that they have access, because never before in history has there been a time when the government has had legal access to something, but not technological access. And you can imagine a world where there was the unbreakable safe. And they couldn't get in. So they have the right to search the safe, but they can't get in. The thing about that is those safes are probably very expensive and used by very, very, very few people, and also not protected by the First Amendment. So they could say, no really, really nice safes like this. They could ban them, they could outlaw them. And that's where encryption is a little different, right? It's protected by the First Amendment, so they can't outlaw encryption itself. There's a First Amendment right. So legislation for mandated backdoor, there's been a lot of conversations about what could happen with this. Well, it's constitutional. The All Writs Act, again, does not give this authority and unreasonably burdensome unless it already exists. And so it's currently unlikely to happen. Comey came out and said, please, Congress, look into this. And the House of Representatives were like, no. This is not going to happen. We don't want to install backdoors. They argue that law enforcement has blown whatever chance it had at public support. Congress, obviously, if you've been paying attention to the news, the people are kind of angry about the spying that's been done by the NSA. And so Congress just doesn't want to get involved in this debate. And so as it stands, the FBI is battling some fierce legal headwinds, right? They have the First Amendment, the Fourth Amendment, and the Fifth Amendment all kind of playing around in this scenario where they're kind of cornered. And that's why this conversation is happening. They're going, we don't know what to do if encryption is by default and no one is giving over their passwords. If this information, it's going to be significantly harder for us to do investigations. And it is going to be harder. As usability becomes standard, as more and more stuff encrypts, which is, I think, a very good thing, it's going to be significantly difficult. And I think their worries are realistic and potential. But, what can they do? Especially if Congress isn't agreeing with them. So that's why we're seeing a lot of intelligence agencies and using this kind of side channel to weaken encryption. If encryption is implemented perfectly, they're kind of stuck. And so, there were a lot of stuff coming out recently where we saw where encryption was weakened, and VPNs, et cetera, and taking a look at kind of what technologies. And they were very happy that they were able to do this, use backdoors, find weaknesses, because it kind of makes it a lot easier for them. And they're not as, if, you know, imagine in a perfect world, you have lawful access to all the data. Technically, using a backdoor to gain access to that, if you have lawful access, if you have a court order, is not unconstitutional. It's not violating your rights. So they could brute force your computer if they have lawful access to your computer. So I'm gonna, you know, take a shift back a little bit to my research. It's kind of on the softer side, not technical side, but, you know, what do users think about encryption being turned on by default? So again, 477 people were polled, and most of them were from the InfoSec community, and a lot of people strongly agree. So most of the people say, yeah, it should be on by default. But there was a big split, even if it was InfoSec. Basically, I asked, you know, should the government be able to force an individual to decrypt with a court order or a warrant? Imagine a world where you can't use self-incrimination. And about 31% agreed, and 17% were neutral about it. So it's almost a 50-50 split. If you assume the neutral people could go maybe towards the agree or maybe towards the disagree, it's unclear, but that's a pretty big split. But in chopping down that data, the people who agreed with this past statement said were more casual about their privacy rights, obviously. And other questions, they were less casual about protections. And then almost all of them believed that in a fundamental right to privacy. And this is where they're splitting, is even though everyone has this fundamental right, now they're saying, well, this balance that was created by the Constitution, maybe that balance should still exist in this space. And so it's not necessarily with respect to the privacy rights that they have, but they're okay in trusting the government and the system. And the disagree people were more likely to use disk encryption or password protect a phone, and both disagree that encryption is only for those who have something to hide. And we saw that poll earlier. So going forward, like, what do we do? Is this a bleak, you know, situation? How are we going to handle this continuous call for a backdoor? Right now, the balance is upset. The police have lawful access, but no technological access. That really scares them. And, you know, I talked about mechanical safes before, and that really is kind of the only situation before where maybe the government didn't have technological access to something. And so this is a new realm in the legal world that didn't exist. And will encryption be something that is just has its own case law that is completely treated differently than anything else, possibly long term down the road, maybe. But right now we're applying the laws that have existed for a very long time to something that the founding fathers could have never imagined. And so kind of what's next? And I think more encryption. We're going to use it. It's great. We should encrypt everything. Privacy is a real serious issue. You know, I hope that there will be more established Fifth Amendment case law coming in this area, that more courts will address this issue so that we have a clearer picture of what it means with the foregone conclusion and your right to not give up a password. You know, I think there needs to be a larger legal debate about the balance. Where should we be? Right now, I don't think I have a good answer to solve this problem, because I do believe that encryption should not be weakened. However, what do we do in the long term if the courts can't ever have real access, but they have legal access? So we continue to work out in the courts, and probable cause. I think we might see a little bit more in this space about how encryption plays a part in the probable cause analysis. I don't think it will be a huge issue, but I think it will be something worth watching, because more and more people will have encryption, and I think you'll see some court cases where they're saying, well, in the probable cause analysis, you know, he had a flag on his record because he was previously arrested for a sexual assault and his computer was encrypted. Like, we think there's something on there. And will that be enough to get a warrant to either arrest or search his computer? So never before in history has the balance between police access and the people been so tilted towards the people. It's not necessarily a good thing or a bad thing. It's just unlikely that the founders of the Constitution ever envisioned something like this. And this balance will continue to likely tilt towards the people. As far as encryption goes, if mass surveillance continues to be an issue, more people are going to respond with, let's encrypt more, because this trust that we originally had in the government for the balance to healthily exist has really been upset. And once everything is encryption and decryption isn't possible, will investigations be regularly thwarted? And we'll see maybe more of that. Right now, I don't think it's happening very often. But I'm not in the FBI doing groundwork right now, so I can't say for sure, but I don't think it's a huge issue. There are still regular people getting arrested all the time. And so maybe there will be a congressional response to this. It's unclear. But what I hope you take out of this presentation is that it's a really complicated issue. And the reason the FBI is responding the way they are is that they're legitimately scared. And this is a technology and a situation that they have not been in, and they're unsure how to handle. And I think encryption is great, and we should use it, but we should think more deeply about the issues, about what should the balance be. And maybe the balance should be completely for the people. But I hope that's what you take away from this. So I think I have some time for questions. So thank you so much for coming, and I will take questions. Yeah.
You gave us some great snapshots on how users feel about this and they believe what people are saying is biased. But can you give us any insight, perhaps exactly when these surveys were conducted? Any trends that you've noticed in light of the direct focus statements, Apple and Google use, perhaps the leaks, if you see any trends?
So quickly, the surveys were done in October 2014, and I will be launching, I had hoped it would be ready for my presentation, but I will be launching another survey that's a broader look at this situation, because it was only 15 questions. Do I see any trends? I don't know yet. I think as I gather more data and look at if I have a change in responses as I gather more, because I'd like to look internationally at this issue too. I think most of my respondents were from the United States or English speakers who had access to Twitter or who had access to a computer. But I think I'd like to do paper surveys and kind of look at a broader set. But I think users generally are in the direction of encryption is good, but they don't necessarily know what that means. It's kind of interesting in hearing personal feedback. A lot of people said, like, you explained what encryption is, but I still don't get it. And this is really confusing to me. And I thought, really? Oh, geez, like, I need to be more simple, I think, in my way and the way I approach it. So I was actually shocked at how many people didn't understand encryption or know its significance. Any others? Yep. That's a great question. So the question was, if the government compels you to give information, is it to give the password or a decrypted version of the data? And if you give over the password, could they use it on other devices? So first, I'll answer the latter question. Yes, they can use that password on other devices. So if you give up the password, the court order can ask you to give up a password or give decrypted information. It could be either. So in that case, like, I can imagine hypothetically, I'd say, well, let's just give a decrypted version of the information, because there is that scary factor that they could then go use that password or that knowledge about that password. Maybe it was your dog's name and 123, or password with 2 money signs. Because I think there was a Fox News article or show that he recommended that's what you should do. But they could use that. They could use that to decrypt other devices or use that knowledge. Any other questions? Yeah. I don't know. That's a really great question. I don't know of anything off the top of my head. I think it comes down to, as written documents were encrypted, that was mainly used by like individual governments and not so much by individual people. And so I think there probably just weren't enough cases where it ended up being case law. But that's something like worthy of doing a little more intense research on. But I don't know off the top of my head any like situation. Yep.
So a lot of countries have regulations saying that travelers cannot bring encrypted devices in. Every device nowadays is encrypted, it sounds like, soon to be. Do you know how countries like China are looking to actually enforce that, or possibly change anything? Are there any concerns there?
So that's a complicated question. It depends. Oh yeah, sorry. His question was, how are countries that outlaw encryption when you travel and all these devices are encrypted? How is it handled? It depends on the individual law of that country. It could really, it could depend. Once you're in their country, you're kind of in their jurisdiction. They could arrest you until and they could throw you in a prison, technically, if that were the law, until you decrypt. In the UK, for example, there's a law that says if we ask for your password, you must give it to us. You must decrypt, and we can put you in jail if you don't. And so that's where it's kind of scary. So I know I've heard some people's solutions is they just don't bring devices. They kind of work on the cloud for the most part because they don't want to risk any sort of situation where they'd be detained. I think I might have time for one more question. Yes?
I read that the border search exemption actually extends 100 miles in from any border. If you look at what that covers, it's a significant portion of the country. Do you see the government using that as an end run around these technologies or around requirements for warrants, or is that really not starting to come up yet?
I think they can try. This is funny because I've given a talk on that exact issue. Oh, sorry. I'm sorry, I'm so bad at this. The question was the border search exception. The government has come out and said there's a 100-mile radius basically for the border, and that includes international airports. So imagine that's most of the United States. And she said, is that an end runaround to these laws? Lawful access. Absolutely, I think they've tried. Whether or not the courts actually recognize that, no. I don't. I mean, it's happening, I'm sure, and I think, in some cases, but it's not something they should abuse. And they can claim that 100 miles, but there's no court decision that says that the border is 100 miles. So what the FBI is going to argue and really go after is not necessarily what the law is. So that doesn't mean that the law is that the border is 100 miles. So thank you so much again for coming, and if you want to chat afterwards, I love this stuff, so.